I hope I can take you through succession and estate planning in this introductory session. Um, we Succession and estate planning is an area of law which is often neglected, and people tend to leave. Culturally, we see that Indian clients are usually reluctant or hesitant to think of their inheritance and plan for the eventuality of death. However, it is an extremely important way to ensure that the property and estate of the person passes from one generation to the other. Usually, we see clients leave estate planning for for their golden years. This again comes with its own problems, because by then you may be at an advanced age, and there may be other physical or mental issues. Therefore, it is advisable that as soon as you feel that you are ready, you have sufficient assets, and if you have large family, it is advisable that clients should start planning for their estate. In fact, in my experience, I have seen a person who was just 40 years old and passed away. But thankfully, he had the foresight to prepare an extremely detailed will. He provided not only for his ex-wife and his current wife and his child, but even down his driver and servant. So it was just because of his foresight that he was able to divide his properties in a manner which he wanted to, and not as per any general rule. Now, to start with, what happens if a person does not leave a will or does not plan for his estate or dies suddenly? Um, then the person is said to die intestate, that is, without any will. If a person dies intestate, then they are governed by their personal laws. So Hindus would be governed by the Hindu Succession Act, Muslims would be governed by the Muslim personal law, and so on and so forth. The personal laws come with their own set of rules, and properties are divided in a particular manner. For instance, under the Hindu law, you have a concept of class 1 and class 2 heirs, and class 1 heirs would take precedence over class 2 heirs. Similarly, there are detailed rules in all the personal laws. Now we come to a will, and what exactly is a will? Now, a will is a legal declaration of the intention of the testator with respect to his property, which he desires to be carried into effect after his death. Now, when we speak of will, you will hear a few terms, and this is for very junior law students or associates. I will just explain the terms just so that you don't get confused when we are discussing the concept. The first term is, of course, testator or testatrix. This is the person who prepares the will, on whose behalf the will is made, and in that sense, whose property is in question. The in a will, usually the person appoints an executor. An executor is the person appointed under the will to carry out the wishes of the testator after the death of the testator and when the will comes into effect. You could have one executor, two executors, multiple executors. They may act jointly, they may act severally. It is all as per the wishes of the testator. Then we have beneficiaries. Beneficiaries are the ones who receive the property under the will. And then we have a concept of attesting witness. This is a witness who affirms that the testator has signed the will, and he himself also signs the will. Now, who can make a will? A will can be made by any person who is a major, is of sound mind, and with free consent. I'll explain all these three concepts. First is a major. That means a person who has attained the age of 18 years. Under the Indian Majority Act, the age of 18 is the age by which you become a major. So anytime after that, a person can execute a will. The person must be of sound mind. Now, a person must be able to completely understand the contents of the will. If the person does not know the contents of the will, even that may be on account of even intoxication or some illness, then such person cannot execute a will during that period. However, even if a person is ordinarily insane, if he has a lucid period or a period when he is of stable mind, in that period he can execute a will. So therefore, the soundness, whether the person is of sound mind is extremely important. This is one of the primary reasons on grounds on which wills are usually challenged. Since, like I said in the beginning, wills are usually made at an advanced stage when the person is, 70, 80 years old. And whether the person was of sound mind or no is something which is usually raised as a ground for dispute. The third aspect is that it has to be done with free consent. Section 61 of the Indian Succession Act provides that a will must be completely, the person must execute it freely and without any fraud or without any coercion. This could be coercion or fraud at the behest of a child, of a spouse, of an outsider. It could be anybody. So the a person must uh, it will have to be proved that the person had done so freely and of his own volition and not under the influence of any other person. This again is a large ground for challenging of a will, because usually heirs who are left out of the will may have a grievance against the will and may say that it was made at the behest of the child who has inherited all the money to the exclusion of the contesting party. Now, how does one make a will? Technically speaking, there is no specified format for preparing a will. Will can be prepared on a plain paper and in layman's language. However, it is essential that the intention of the testator must be clearly set out. Therefore, we often see that people do seek professional help for drafting of a will. But technically and legally speaking, there is no real need for, there is no specific format, and any person can execute a will. The will has to be signed by the testator, or he must affix his mark if he is unable to sign. There are also instances where if a person is unable to sign, he can give instructions to another to sign, but that requires a lot of proof at the time of proving the will. So ideally, yes, the testator himself must sign the will. The will must be attested at least two witnesses. So a minimum of two witnesses are required. You could have more number of witnesses, but a minimum of two witnesses are required. Uh, the witnesses must sign in front of the testator. The testator would either sign in front of the witness, or the testator must personally acknowledge to the witness that he has executed or he has signed the will. This is something that the witnesses will have to subsequently give testimony at the time when the will when we apply for a probate. Now, will comes into effect only after the death of the person. Therefore, a will can be changed at any time during the lifetime of a person. And it's as simple as just drawing up a new will, and old one will cease to exist. So whichever is the latest will at the time of the death of the testator, that would be the will which would be taken into consideration. You may also come across the term codicil. Codicil is like an amendment to a will. If you do not want to change the entire will, and if there is only a small portion of the will that you would like to change, then you can execute what is called a codicil. This is the basics of how to prepare a will. Now, what is the property which can be included in a will? Any movable or immovable property which belongs to the testator, including his share in undivided co-parcenary property or joint family property, can be willed. There's a joke in the legal circles that you can will away the Taj Mahal. Well, technically, you can put anything in your will, but the bequest will not be successful unless you have a legal title to that property. So the will only states the intention of the testator that this property must go to X, Y, or Z, and thereafter it has to be proved, and action has to be taken based on whether the person had a legal title or not. Now, who can inherit property under the will? Any person who can inherit property under a will. And however, you cannot make any bequest in favor of a person who is not born on the date of the testator's death. So, for instance, if A makes a will saying that rupees 1,000 has to be given to his first grandchild. Now, this may be a will made early on, at which time he did not have a grandchild, and he says that okay, as and when I pass away, and if I have a grandchild, this 1,000 rupees must be given to my first grandchild. Now, on the date of the testator's death, there is no grandchild. None of his children have had a child, and therefore there is no grandchild. So, such a bequest would be void. So this is broadly on who can inherit property under will. The next is registration, whether registration is necessary. Registration is completely optional. A will need not be registered. If you wish to register a will, you may register a will, but it is not essential or mandatory under the law. Now, some practical tips which we come across at the time of drafting of wills, as well as at the time when we go to court in an testamentary suit. Firstly, the will should be as detailed as possible so as to avoid any confusion after the death of the testator. One must understand that the testator drafts the will and the will comes into effect only after his death and is interpreted by the executor or by persons who may not have been party to the drafting of the will. And the testator is not around to explain his intention to the executor. Therefore, it is very necessary that the intention is spelled out correctly. Secondly, it should be as detailed as possible because in today's day and age, there are many modes of investment. There are mutual funds, there are bank accounts, there are so many ways in which we invest our money and our property. And often other family members may not even be aware of where all our investments lie. Therefore, it is better to mention in as much detail as possible so as to simplify the job of the executor so that he can execute the will in an easy and convenient manner. Second practical tip would be that the witnesses should be known person, and if they are not known, there is no requirement in law that the witness should be a known person. But if the witness, ideally one should mention the full address and contact details of the witness in the will itself. This helps the executor or the heirs to get in touch with the witnesses. This is because there may be a case where a will is executed, say, in the year 2000 and the person passes away in 2015, 2016. The testator knew the witnesses well, but the executor or the heirs may not know the witness or may not have any contact details. We have seen parties scrambling for looking for their witnesses because it was some person in their father's office or in their mother's office, and therefore they don't know who that person is, where that person is now 15, 16 years down the line. So therefore it is always advisable to put in some contact details of the witness as well. The beneficiary, ideally, the beneficiary cannot be a witness. That the executor can be a witness, but the beneficiary should not be a witness to the will. If the testator is of an advanced age, it is also useful sometimes to have a doctor as a witness. This is so that the doctor can then certify of the mental fitness of the testator at the time of executing the will. Again, these are all practical tips. There is no requirement in law for any of this, but these are advisable. The next is, of course, always ensure that there is a residuary clause in the will. Sometimes a residuary clause is like a catch-all. Basically, if there is any property which is missed out or any small investment or something which is missed out, a residuary clause helps in that in anything which is missed out, which can then go to a designated person. This always helps, and it could be useful. And lastly, the original of the will should be kept with a trusted person. It could be kept with the executor himself, or any heir or family member or whoever the testator trusts. This again is important because if the document is made and kept somewhere and nobody knows that it is made, then it is of no use because the person, the executor must know that he has to take these steps or he has to take this action. Therefore, it should be given to some trusted person. So this is as far as wills go, and it's a broad guideline on how to prepare a will and what all should be included. Now, the next is probate. And now, what is a probate? Probate is basically an official proving of a will. It Upon the death of the testator, the executor will apply for probate. Now, probate is mandatory only for Hindu, Sikh, Jain, Buddhist, and Parsis. And if the will is executed in certain territories, that is in Calcutta, Chennai, and Mumbai, or if it relates to if it is executed outside these territories but relates to immovable properties situated within these territories. Now, probate is, however, not mandatory for Muslims and for Indian Christians. So, therefore, it is not, even if it is executed within these territories or it relates to immovable properties within these territories, it is not mandatory in law for them. Now, what exactly, however, applying for probate or getting a probate, it makes it easier to transfer certain properties, and sometimes some mutual funds or societies may insist on it. So it is an option available, though it is not mandatory in some cases, as I mentioned above. Now, what exactly happens and what is the process of probate? I'll tell you what we follow in Bombay since I practice here. Now, at the time of applying for probate, the executor has to file a petition in court called a probate petition. Along with, he annexes the will, and he also annexes affidavits of the attesting witnesses. The attesting witnesses will confirm that, yes, they had seen the executor sign the will in their presence and that they had also signed the will. Similarly, the executor may also attach the consenting affidavits of heirs with consent to him being appointed as an executor and for the probate being granted. The process that is followed is that once the probate petition is filed, a notice is issued to all the heirs, and a public notice is also issued so that anybody who has any objection to the probate being issued can come forward. If a probate is not contested in Bombay, it usually takes 8 to 10 months to receive a probate. However, if any of the heirs contest the will, then it gets converted into a testamentary suit, and then it is tried like a regular suit, and it takes its own time, and then the will has to be proved, and the heirs who are objecting to it can state grounds on which they object to it. Now, in the absence of a will, or if an executor is unwilling to act, the heirs may apply for letters of administration. That is the other term that you may come across. So they may apply for letters of administration for distributing the assets of the deceased. So this is as far as wills and probates go, and this is, like I said, a very effective and convenient way of disposing of property and planning for your future. Another concept which is also popular when we speak of estate planning is setting up of a trust. Now, there are two types of trusts. There is a private trust and a public trust. Public trusts are trusts created for religious or charitable purposes, and they relate to an uncertain, fluctuating body of persons. Today, we are not dealing with public trusts. I will speak to you only about private trusts. Private trusts are trusts which are created for the benefit of specific individuals, like, say, family members, and it's governed by the Indian Trusts Act. Now, again, the terms that you will come across in this aspect are, one is a trust is set up by a person who is known as the author of the trust or a settler. The next term is trustee. Trustee is the person who accepts the confidence and in that sense carries out the purpose of the trust. Beneficiary is the person for whose benefit the trust is created. And trust property is the subject matter of the trust. That means some property which is the basis of the trust. And a trust deed, which is the instrument by which the trust is created. Now, who can set up a trust? Any individual who is over 18 years can set up a trust. A trust can also be set up by minors with the permission of the court. Now, apart from individuals, even a company, a firm, a society, an association of persons, all of them are capable of setting up a trust. A trust can be set up in two ways, either during the lifetime of the person or by way of a will. That is, the trust is set up as part of the will. Now, what are the essential conditions for a trust? Section 6 of the Indian Trust Act sets out 4 essential conditions for a valid trust. One is unequivocal intention. There should be no ambiguous language. There should be a clear intention of the property vesting in trust. Secondly, the purpose or objects of the trust must be clearly defined and specified. The settler of the trust must in detail set out what is the purpose of the trust and how he wishes to achieve it. And trust can only be created for lawful purposes. If there is any illegal or unlawful purpose, then of course that such a trust would not be valid. The beneficiaries must be clearly specified. It must be said that, okay, the names of the people or the child of so and so, it must be specified. If it's a very general or ambiguous, it can be void or it can be set aside, or it could create other problems. And an identifiable property must be transferred or settled in the trust. It is settled law that when there is no transfer of property, there is no creation of trust. The trust property could be the movable property or immovable property. Property that cannot be part of a trust, property belonging to a waqf, property of HUF or religious charitable endowments, all of this cannot be trust property, and therefore that cannot be put in trust. Now, when we speak of trust, there are different types of trusts. There is a revocable trust. A revocable trust is a trust which can be revoked at any time by the settler. The settler must only reserve a right in the document to revoke it at his will. An irrevocable trust. Trust will come to an end. It will not come to an end until the purpose is been fulfilled. That means at no time can it be revoked. I'll explain this a little later in more detail when we speak about extinguishment of trust. Then a trust can be discretionary. That means the trustees have the discretion to decide who among the beneficiaries should get a big benefit and how much and to what extent as well. So the trustees have some discretion. And the fourth category is a determinate. That is, the entitlement of the beneficiaries is fixed and the trustees have no discretion. They just have to carry out the wishes of the settler. These are the 4 aspects of types of trust, and usually it is a combination. So it could be a revocable discretionary trust or a revocable determinate trust or irrevocable discretionary trust or irrevocable determinate trust. Now, who can be a trustee? Any person capable of holding a property can be a trustee. So even a minor can be a trustee. However, if the trust involves any discretion, exercise of any discretion, then the person cannot execute or cannot execute it unless he is competent to contract. So then a trustee has a fiduciary responsibility under the Act. He is responsible to execute the trust in a just manner, and he's also responsible for protecting the trust property. He has a fiduciary duty towards the beneficiaries. If a trustee does not act as per the terms of the trust, then he can even be liable for breach of trust. So therefore, it's a very onerous responsibility and should be dealt with accordingly. Now, extinguishment of a trust. Section 77 provides the manner in which a trust is extinguished. One is when the purpose is completely fulfilled. When, for any reason, the purpose becomes unlawful, though it may have started as a legal trust, but for some reason, change of law or anything like that, it becomes unlawful, then it would get extinguished. Fulfillment of purpose becomes impossible by destruction of property. So like we said that that it is essential that there must be a property in trust. For some reason, if that property is destroyed and is no longer available and it is not possible to fulfill the purpose, then the, the the trust comes to an end and is extinguished. And or and the last is if the trust, being a revocable trust, is expressly revoked. So if a trust is a revocable trust, as I explained earlier, then of course if it gets revoked, then that's the end of the trust. Now, I had mentioned that irrevocable trusts cannot be revoked. Irrevocable trust cannot be revoked by the settlor. However, it could be revoked by the consent of all the beneficiaries if the beneficiaries are all competent to contract and they all agree that yes, this trust should come to an end. Then the trust can be, even an irrevocable trust can be revoked. Now, what are the benefits of setting up a trust, and why should one look at setting up a trust? Trust is usually we see set up by high net worth individuals who have a lot of properties and a lot of business and who may have large families and complex family relationships. It is a very effective tool for transferring property from one generation to another and providing for for several for the next generation. It also allows for ring fencing of assets. So therefore, personal assets can be separated from business assets and can be protected. End use of can be monitored. The settlor, in that sense, has great control and can keep, depending on how the document is drafted, great control on how the benefits are to be given to the beneficiary. The settler can even attach conditions to the gifts. Some could be very strict conditions as well. For instance, a settlor may say that my grandchild will get a benefit of say ₹1,00,000 if he completes his PhD. So he can attach any condition to the gift. It is also extremely helpful in when people have children with special needs. This is something which often is a point of is a cause for worry for parents who have children with special needs, that what happens to those children after the parents pass away. So this may be a very effective tool to help in such children. It also bypasses the probate process, so therefore there's no probate required in terms of a trust, and they can go ahead with the planning of the trust. Another important benefit of setting up a trust, which people are considering now, is that there is a looming threat of the inheritance tax being reintroduced. The inheritance tax was something which was enforced in 1985, and thereafter it was abolished. The inheritance tax basically taxes a inheritance which a person may receive by way of will or so therefore or through succession. That a trust, if certain types of trust, like an irrevocable determinate trust, for instance, can be worded in a way that it may not its inheritance tax may not be levied on such trusts. Of course, as and when, if the inheritance tax is introduced, the way it is worded, whether it would cover trusts or no, would have to be seen when the law is introduced. But this has been a looming threat for many years. In fact, if all of you follow the news, just over the weekend, there was a paper which was floated where certain IRS officers had suggested that inheritance tax should be reintroduced. Of course, this morning's paper reports that the government has set up an inquiry against them because they did not have any authority to issue such a paper. So this is broadly why people set up a trust. I think I have covered everything that I plan to initiate.
So the first one is, what if the witnesses expire before the executor?
Okay. Yes, that's a good question. it is necessary, of course, for the attesting witness to be present, but there could be a situation where the attesting witnesses are dead or are not traceable for some reason. It is still possible to prove a will. The question you said was before the executor. I think what the person means is before the testator.
Yes.
But yeah, so what happens is, so when we apply for probate, for instance, if the witness is already passed away or is not available for any reason, then the way of proving the will becomes a little more cumbersome and a little more tedious, but it can be proved. We then look to section 69 of the Evidence Act, and we look at the provisions of the Evidence Act, and we would have to prove the signature of the will and prove the signature of one of the attesting witnesses at least. So we would need other documents which show their signature and prove it on that basis.
Okay.
So it is possible, but it's a little more cumbersome and a little more difficult to prove it. If the executor is not available, or if the executor is dead, I'm answering a second part of the question. If the executor is dead, then any of the heirs can apply for letters of administration with a will attached instead of a probate.
The next question is, on what grounds is a will challenged? How to prove that the will was made freely and without undue influence?
Yes. So the will is usually challenged on two grounds. One is that the person was not of sound mind, and secondly that the person was coerced or forced into executing a will. The way to prove it really is by leading evidence surrounding the day on which the will was executed. So the attesting witnesses would have to put in their evidence. They would have to say that they came and they asked, they could just have chatted with the testator, and they would be able to tell, if, like I said, if the person is of an advanced stage, then a doctor may have to be examined, and it would be also be beneficial to have a doctor as a witness.
The next question is, to create reasonable doubt, how can a registered will be challenged?
So the mere registration does not give it any additional, like I said, registration is not necessary. If it is registered, there is an additional level of protection, because when we go to register the document, what happens is the registrar will ask the person executing the document that, have you seen the will? Have you examined the contents and all? But the grounds of challenge would still be the same. You would have to challenge it on the basis of mental fitness and that it has been executed with free consent.
Sure. One of the highly voted questions is, how can a doctor's mental fitness statement or affidavit be challenged?
I think this would depend on the facts of the case, and it will not be possible for me to give you a general answer. It would depend on the age of the person. Then, of course, if the doctor has given his opinion, then we could cross-examine him, get another expert, another doctor's view. So, these are things which depend on the facts of the case. I can't generally answer that query, I think, Sunita.
Sure. Once the probate is obtained, how does the mutation in the property records take place?
So then the property records, that is the next step after the probate is obtained. So till you don't have a probate in place, you cannot go to the authorities and ask for a change in the property records. Once you have obtained the probate, the executor is legally entitled to do so, and then that usual process will follow. So, but the probate proves the will and gives the executor the right to act, the legal right to act.
So there is a question raised that in the current circumstances of COVID, is there a way to prepare a will? There could be unforeseen circumstances in a family, and at such times, if there is no will of an individual, there could be disputes. So what is the way about?
You can certainly draft or prepare a will even in this situation. Stamp paper required. There is no registration necessary. The will can be drawn up on a plain piece of paper. So as long as it is attested by two witnesses, and that is sufficient for proving a will. So therefore, yes, you can definitely execute a will even in this period.
Okay, Shoma, that was the last question.
Okay.
Thank you very much for being this patient and explaining each of the provisions so patiently and so lucidly.
No problem.
Malvika, would you like to propose a vote of thanks?
Yes. On behalf of the plea team and the participants, we extend our hearty gratitude to you, ma'am. Thank you for delivering such an insightful session.
Thank you. Thank you so much for this opportunity. It was great. We are all adjusting to this new normal. So this was a great opportunity. Thank you so much.